You late well on. You have not been here for the whole of the proceedings this morning, but I missed an hour having sat and listened to the Honourable Gentleman Hammersmith for an hour and a half, and I had rather anticipated that I would have come back to find that the first speech of the day had concluded by the time I returned. And I just really want to register my concern, as I think you have, that if we continue progress at this rate, that is going to have implications for obviously the consideration by this committee of the rest of the bill. And I just simply make that observation, having now been here, we've now been here for 2.5 hours and still on the first speech on the first group of amendments.
Well, I'll deal with this point of order first and then come to you, Mr. Watts. Mr. Blunt, I think you can be reassured that everything has been in order, and both you and I will have the benefit of listening to Mr. Slaughter, because both you and I have had the misfortune not to catch the whole of his speech this morning. And if it is in any way disorderly, then he'll be asked to cease. Mr. Watts.
Point of order, Chairman. Just for your information, we had a similar point of order at in this morning's session. I'd just like to be reassured that the government benches won't try to dictate to the chair whether something is in order or it is not in order.
Can try to do what they like, but it's up to the chair to decide what is in order and what is not. And we will listen to all representations fairly but firmly. Mr. Slaughter.
Mr. Holborn, it's a great pleasure it would have been a pleasure in any event to welcome you to the chair, but having seen you stamp your authority on the committee from the first moment, I doubled my appreciation of your being here, and if I may say so, I did think the comments from the minister who was not here for the part of the morning session, but did have a touch of lèse-majesté about them, and I'm sure now that you are firmly in the chair that you will control proceedings in your own manner. And on that subject, I would simply inform you, Mr. Holborn, that we've had a very inclusive debate this morning, with the exception of the President Minister. I think all members have had their 5 pence worth so far, and a lot of very good points have been made in interventions. And the final point I would make in my exculpatory statement is that I was, in any event, drawing to the end of my preliminary comments.
I'm very grateful for my honourable friend for giving way once again. Just before he does, he will remember the comment that was made by the opposite benches about local authorities' ability to support services like the Citizens Advice Bureau, at which he drew to the attention that some councils were actually making a bigger contribution than others. Can I suggest that he reads the Sigoma report, which demonstrates how hard the cuts have hit some of the most deprived councils in Britain, and that's probably the reason why they've struggled to maintain the resources for citizens' advice, because so far the government's cuts have not hit across the board. They've hit the most deprived communities hardest, and they're just the same communities that will have even more pressures on them in the citizens' advice if the bill goes ahead.
Well, thank you, Mr. Holborn. I think that that's right, and I'm also grateful to my friend for reminding me where I was. That I think I was trying to conclude, but answering the point from the right honourable member for Carshalton and Wallington. And when I said preliminary comments, I wasn't being entirely flippant. What I've done is I've spoken to all the amendments in the first group in my name. I haven't addressed those which are in my colleagues' names. I'm anticipating that they will deal with these matters so comprehensively that I won't need to rise again. But of course, if I feel the necessity, I will avail myself of that. But to conclude on the point, Royal Member Cross from Wallington, I'm slightly surprised. I was addressing the issue right at the end of the last of my amendments, Amendment 61, in little subclause 9. The Lord Chancellor must each year lay before Parliament a further report describing his opinion the extent to which any changes he has made to the amount of expenditure of civil legal aid that has caused additional costs to other departments of state. And I've simply made the point, I'd used the example of homelessness and possibly the greatest leverage or the greatest disparity between the benefit of early advice and the cost of that and the actual cost of homelessness, and that could be a factor of some thousand. But the analogy works for other branches of social welfare legal aid as well. And I said that the decline in CABs, law centres, advice centres generally, was preventing that early advice taking place and hence was likely to lead to exacerbated costs. And although I accept what the Honourable Gentleman said, which is that some local authorities, and all credit to them, have protected their advice agency, the overwhelming pattern is, as my friend said, that most have made cuts, some have made very deep cuts, up to 100%. They tend to be in the areas where they're most needed, the most deprived areas. And I would not like the misapprehension to be given to the committee that this is somehow a swings and roundabouts situation. It clearly isn't. And I was slightly surprised, for Alderman Wallington, I was pleased to see a signatory to the Justice for All campaign, EDM 1194, which says that the signatories regret the reduction in spending on legal aid, the restrictions in scope and eligibility, and the blanket 10% cut in the lowest fees paid to providers of legal services is having detrimental effect on access to justice and on the well-being of the most vulnerable people, and calls on the government to rethink the provisions of legal services for the poorest in society. And I'm sure there's a comments that the Honourable Gentleman is going to amplify when he addresses this matter today or whenever. And I hope he was also a signatory to the excellent motion that went to Liberal Democrat conference, which said, inter alia, and it's a very long motion, I'm not going to read it, a properly funded system whereby access to justice in the courts is not denied to those otherwise unable to bear the cost is the mark of a modern, civilised and democratic society. I couldn't have put it better myself, and I hope we'll hear more of that and less of the swings and roundabouts from the right honourable gentleman. I'm going to conclude with just addressing two matters that were raised this morning which I couldn't address at the time, and I apologise for that. The first was in relation to me. The Minister, and I bet we'll hear more of this from him, was keen to emphasise mediation and the money that had gone into mediation. And I hadn't completely familiarised myself with the submission from resolution. I have had a look at that over the short German, and what surprised me was the vigour of that response. It's actually, of all the responses, and I've probably read about 200 now, one of the strongest. This is from one of the leading organisations who would be a beneficiary and whose interests would be promoted by the government, and I'm conscious of that, and I don't resolve from that. Mediation is a good thing. It's a good thing if it works.
So, with the Honourable Gentleman.
Yes.
Well, from my contact with resolution, many of them would argue that other forms, such as collaborative law or indeed court law, may be preferable. They are an organisation of solicitors that deal with family law, not necessarily advocates of mediation per se. Maybe Slaughter.
I think that's splitting hairs. Yes, they are solicitors. One of the principal pursuits is mediation. They are experts in mediation, and their submission supports mediation very strongly. The point that I am making to the Minister is they support it in the context of other remedies. And what they say, and I'll only quote to half a dozen sentences from it, that mediation will continue to receive funding. This is welcome, but mediation is not suitable for all cases. Other valuable non-court options appear to be ignored. There needs to be funding provision for cases where mediation is unsuitable or fails, e.g. where one party refuses to take part. They make some general criticism of the bill, that's right. The government is underestimating the vulnerability of separating couples and their children. It mentions that 95% of civil and family legal help recipients in 2009-10 were the bottom two income quintiles. That's worse than the situation I painted, that it was 80%. They say legal aid will be available for representation in 34,000 fewer private law children act cases, 75% of the proportion of existing cases. And they say mediation will be the only option available to families who qualify for legal aid. The proposals fail to recognise the important role tailored legal advice plays in helping couples reach agreement. In order to negotiate sensibly and reach fair agreements, couples need a proper understanding of their legal rights. Families need tailored legal advice specific to their particular circumstances alongside any dispute resolution process. Yet under these proposals, funding for legal advice alongside mediation is limited to the £150 per person with an additional one-off fee of £200 for the drafting of a court order setting out the terms of settlement in finance cases. Legal advice supports the parties, and here, and honourable member who are interested in the Commonwealth jurisdiction will note, it is worth noting in Australia, family relationship centres were initially established and designed to actively discourage legal advice and input from lawyers, but this policy has now been reversed and increasingly lawyers attend dispute resolution sessions with their clients. The proposals appear to ignore other solutions, including solicitor negotiation and collaborative law. If all cases are pushed into mediation, the success rate will worsen and the process will be undermined. Legal aid should be available for family law cases when mediation fails or is deemed unsuitable by the mediator. So I don't think you can get much clearer than that.
I'm very grateful. Would you agree with me? It takes an absolute genius to come forward with a bill that the beneficiary of that bill, the only person who hasn't got their budgets cut, in fact there's no limit on their budget, for them to join the wide chorus of opposition to this bill.
Well, in fairness, resolution, they don't want to be set up to fail. They don't want to be in the position whereby they are being held up as the, you know, as a golden fleece. Is that the right expression? By the government, golden something, and said this is the solution. When they know they're part of the solution, and we'll come back to this later, I'm sure, in the autumn. But this is the point that the government does need to address. And I hope they will address that, and they may consider bringing forward amendments. The position of families and of children, and I say I had a very interesting session with Just Rights. I don't know whether the Minister has met them yesterday. 30 organisations representing children, representing their concerns of how children will be particularly disadvantaged by this Act. It isn't only families, it's children as well themselves. The final point I'll make on mediation is that most cases, most family cases, are settled outside court. I think over 90%. Very, very, very few go into court. The benefit of advice from lawyers, the ability of lawyers to negotiate and reach a consensual solution is almost completely disregarded by the government. And of course, that is at a much lower case. The government is looking at those cases which are litigated, which by definition are the most intractable cases and are likely to be the cases which are least suitable for the end. The final point that I was going to make, and again I'm sure we'll come back to this, comparative jurisdictions. Can I just place this on the record? I've mentioned already that the inaccurate figures quoted in relation to New Zealand, the £8 rather than the £20 where we actually are. And I heard a sedentary intervention this morning. Yes, well, that's still half the cost. I indicated that there were other factors that would explain that. But I think perhaps the best rebuttal point here is when one looks at the total costs of civil or criminal justice systems in whatever jurisdiction, and I think that is the fair comparator, it gets rid of the differentiation between adversarial and inquisitorial systems, between Roman law and common law jurisdictions. It perhaps does not get rid of some of the social differences, but at least it is a comparison. What developed countries pay for their legal system. And the figures, and these are provided by the European Commission for the Efficiency of Justice. They are comparable figures, unlike the ones the government chooses to use. The total spends on the judiciary and courts, including legal aid, are per capita England and Wales £75, Spain £86, France £57, Germany £106, the Netherlands £114, Belgium £79, Sweden £73. So we are, well, possibly in the middle, possibly towards the lower end. And for information,
Isn't it the case that all of the countries he's just mentioned are countries with entirely different legal systems? And if we look at the common law system, such as Canada, we find that the cost of legal aid is a lot lower? And would he specifically like to comment on the income thresholds to which legal aid is given in countries like Canada?
I'm not explaining myself very well. The point is, if one takes, yes, I will, and I'll explain myself properly. If one takes the overall cost of the justice system, then I think one is making a fair comparison, irrespective of the legal system pertaining to that country. I hope that even the anti-Europeans here are not going to say that there's not a proper system of criminal civil justice in France or in Italy or in Spain, simply because they have a different system of law than we do. And I personally think those are better comparators, because they are societies more like the UK and Canada, Australia or New Zealand. But if it keeps the Honourable Lady happy, the figure for New Zealand, remember that I said the figure for England and Wales is £75, is £109 per head. So it's substantially in excess. And no doubt she will now come back to me and say, oh, that's not a fair comparison. Well, that was my point in the first place.
Ms. Truss.
I asked the Honourable Gentleman what the income threshold for eligibility was for legal aid. So rather than comparing the overall figure, we should be comparing what level of income people have to get to not receive legal aid anymore.
I can't answer that question. I probably should have done, because she was putting that to those questions to the expert witnesses last week, and they couldn't answer them either. So I suspect she may have a niche market in knowing eligibility thresholds for legal aid in every country around the world. And I don't want to trespass on her specialisms. But I do say, with all due respect to her, that is not the point. The point we are looking at here, that is a tiny snapshot. That is one part of the legal aid and advice and assistance system. You would have to look at all the different ways of accessing the courts, all the benefits people could have, the fact that there are in many jurisdictions legal help services which are publicly funded but which fall short of...
Ms. Truss.
I will.
I think it's entirely to the point about the level of income the threshold for legal aid fits in at, because what the Honourable Gentleman and his colleagues have been saying is that these proposals are going to hit the poorest hardest. So we need to look at the definition of what the poorest is in different countries. And if he doesn't have the income comparison figures, how can he say what the relative position is of Britain and other countries?
They're going to hit the poorest hardest almost entirely because of the areas that are being taken out of scope. The changes, for example, in eligibility, although they are important, I don't want to skirt over them, we will talk about them as well. But the changes to scope is what's important here, the removal of entire areas of social welfare, family legal aid, so that it's simply not accessible at all. The reason I'm addressing the overall cost is that that's the way the government puts it. If the statement which the Lord Chancellor gave, the oral statement he gave on the day of the publication of the bill, which effectively is the response to the consultation documents, for what it was worth, he said this: in some cases, the system encourages people to bring issues before courts where other solutions might be better. In others, it enables people to pursue litigation that they would not contemplate were they paying it from their own pockets. That's the government's argument. The government's argument is, and I did say about this morning, is people are going to court willy-nilly, they don't have skin in the game, they litigate too quickly, there are lots of lawyers out there who are encouraging people to litigate. Now, I've said that we don't agree with that in general, and I know that's something else that we'll, yes, in just a moment, that we'll return to. But if that's the way the government puts its case, that we're about, this is a litigious society, this is a society in which anybody without any personal financial risk can get into court, which is a nonsense thing to say. But if that's what they say, then it's a perfectly fair comparison to look at the relative costs of the judicial and justice systems in different developed countries, comparable countries, and when we find that far from being the highest, we are probably below the average, then that doesn't suit the Honourable Lady. I will give way.
Dave Watts.
Isn't the point about this that everyone would agree that mediation should be the first course of action? We haven't any problems on this side of the chamber about that being the main principle. What we're saying is that if mediation doesn't work, people should have access to justice. And what this is doing is it's taking away from the scope of a whole group of people to get that justice, and it's trying to hide it behind the fact that mediation is an alternative plan for the removal of legal aid for whole ranges of work.
It's another fig leaf. And I don't say that in any way to denigrate mediators. I think I've put on the record very clearly the role that I think for mediators, and I work on an enhanced role for mediators. But as far as the government is concerned, it's another one of those, not very convincing excuses, in the same way that you don't need law centres to advise you about welfare benefits because you can ask the job centre about it, and you don't need CABs to advise you about employment law because you can ask the employment tribunal about it. I mean, these are risible explanations and alternatives. And in the same way, mediation has a part to play, perhaps has a larger part to play, but is part of a continuum. And the role and the point, the young lady can answer this point if she wants to. The point the government cannot answer is, if you take litigation, the option of litigation out of the system altogether, it not only removes a provision for those cases where it is necessary, which are a minority of cases, most cases settle one by another, or find alternative dispute resolution mechanisms. It completely changes the game as a whole, because everybody knows, particularly the truculent party who doesn't want to cooperate in the mediation or whatever else is on offer, that they know that there's no stick to go with the. There may be a carrot to go to mediation. There may be a mediator available and say, I'm willing to do this. But there's no longer the possibility of saying, well, look, you've played around for too long on these issues, whatever they are, family law issues, contract issues. We're going to have to go to court over this. Yes, sir.
In my constituency, I don't have a law centre. Neither does my excellent CAB have any LSC funding at all. And yet there seems to be no dispute within my constituency that the CAB provides an outstanding service to people throughout my constituency. And as it happens, they found funding through the Transition Fund and from the lottery and other sources. So doesn't he make a mistake when he assumes that you have to have legal advice on certain matters, or on almost all matters, when in fact you can actually have very good non-legal advice from institutions like the CAB who don't necessarily have LSC funding?
It's very, very different from mine. I would probably say that 50% of the cases that I now see in surgery are cases that need legal advice. That is because and I don't know, we all have different ways of doing these things. That's because I will tend to see the most difficult cases and probably spend quite a lot of time with people going through what they're doing. But they are usually issues that have reached such a premium that there may be disputes with public landlord, there may be disputes with private landlord, there may be disputes, maybe immigration matters. They have an element of law in them. They may not be going to court immediately, but that is the situation. Yes, I will.
Thank you. I think the funding of Citizens Advice Bureau is quite a complex issue, and whilst one local bureau may not get funding from the Legal Services Commission, a greater conglomeration, for example in Greater Nottinghamshire, there is a large conglomeration who've joined together who do get legal aid funding, who do in fact go to local bureaus and provide the advice and assistance to the volunteers. And whilst there is a difference between advice about the law and legal advice, I think there's quite often a confusion about that. But I would argue that whilst an individual local bureau may not go to the Legal Services Commission, they may well be part of a consortium like Greater Nottinghamshire.
Yeah, I think that's true. And I'm not going to try and second guess what goes on in Honourable Lady's constituency. There may be private firms who have legal aid franchises. Actually, the problem is, and I'm not talking about the current situation that I explained this morning, whereby my own constituency is becoming an advice desert, sadly. Go back 2 or 3 years when it had on paper very good provision by way of advice, and at that stage even it was still very difficult for people, say, to get housing advice. That yes, notionally there were three different organisations within what's quite a small local authority area that had an LSC contract for housing advice. But the demand was such, even when they were all running full volume, that there was a very, very long wait, perhaps a 2-month wait, in order to get an appointment to see them. So we're not talking about something where there's been, the luxury of advice or lack of a need for advice, and everyone has a plentiful supply. On the contrary, it has been a patchwork for the last 10, 20 years. There are only 56 law centres in the country, so it's not surprising that there isn't one in every constituency. There are a large number more CAB. About half of them have LSE contracts, about half don't. There are other advice agencies that have LSE contracts, and of course there are a lot of private firms. It may be the Honourable Lady's constituents do have to travel if they need advice, but I'm sure there will be people who have to do that.
An honourable friend earlier actually pointed out that I look for the best in members opposite. So I wondered if he would agree with me that the honourable member for Broxlow's campaign to save her local CAB, which is facing a 70% funding cut from the hard-pressed Nottinghamshire County Council, whether he would endorse her campaign, but also can he find a way of reconciling such an important campaign with support for a bill which will not only devastate CABs across the country, but will in fact also have a government that supports a tremendous cuts agenda which is hitting our local authorities.
I agree with that, and I think there is an element of complacency, if I may say so, on the other side. If the fact that there is no LSE franchise, no law centre, no LSE franchise in the CAB, therefore the conclusion is there is no problem that needs to be resolved. I don't think that is the case in any constituency. There obviously is a variable demand, and I mentioned the CAB interactive maps that we probably all saw, which are very good. And I may actually come back to them on a later set of amendments, because they do show a very different pattern in different constituencies. But just as I would, in a moment, just as I wouldn't presume to lecture the Honourable Lady about her constituency, I hope she'll take it on trust from me that in my constituency there is a very great need for legal advice and legal assistance.
Well, I only make this for the record because I think it's very unfair actually to talk about another member of the committee as an intervention on somebody else, and therefore in a way denying us an opportunity to respond. I should just make it quite clear that the CAB in my constituency doesn't receive any legal aid funding, and therefore will be untouched by this bill.
I think. Well, if that's the extent of the Honourable Lady's interest, perhaps we won't see much of her in September. But I think I can be accused of a lot of things, but not allowing interventions, I think, is probably not one of them. Right, I'm going to conclude, and I'll conclude with this point. If I can bring you back to the group of amendments just for one moment. Right. Go back to the amendments for a moment. Where we had got to, where we're ending on, is that this is, we see this bill as removing from people across the country. Maybe it has a differential effect in different areas, I accept that, but to millions of people who are reliant on legal advice and assistance, it is removing not just parts of the service, but whole tracts of service that they will rely on. And what we are seeking to put in to Clause 1 of the bill is firstly to restate the principles which we believe have underlain legal aid 70 years and should continue to do so. And secondly, checks and balances on the Lord Chancellor, who is now aggregating to himself many additional powers, but far fewer responsibilities. And I think that therefore the amendments which we put forward are entirely reasonable. And I will end, this was mentioned, I think by me, in the evidence sessions last week. Even the LSC, which is operates the system currently for the government, has very serious concerns. They say, in their response to the consultation, we have concerns that fee cuts may result in market failure and premature exits from the market, where, for example, a firm or not-for-profit organisation becomes insolvent. Well, in the week that the IAS went out of business, and a year after the RMJ went out of business, when we hear about private firms either shutting up or stopping their legal aid work altogether or not being able to continue with parts of their franchise, when law centres, including those in London, are under threat of closure, and when CABs are looking very carefully at whether they can continue, and in some cases closing or amalgamating. That is the landscape before this bill takes effect. And that's why we ask for support on these amendments. I've said that I'm going to sit down now and I'm going to allow my colleagues to move their own amendments, and I hope that I won't need to add anything further in this debate. But I do hope that I've made the point as clear as I can be, and I've exemplified it as much as I can to honourable members opposite, that these are real concerns. And if this debate is going on for a long time, it is because this is a crucial part of the bill. This is where we define, as a committee, we define what the purpose and function of legal aid is. It is an oversight. I hope the Minister will have the grace to admit that. Isn't an oversight not to define it in his own terms at the beginning of the bill? I would welcome him accepting what we've said in relation to the bill. If he wishes to bring forward his own words subsequently, then so be it. But we cannot go blindly into the future with nothing other than a series of horrific cuts to look forward to for the benefit of our constituents, the benefit of the whole country, for whom legal aid and advice is so important.
Point of order. Point of order. Well, point of order, Mr. Crispin Blunt, and then point of order, Mr. Alex Cunningham.
Mr. Holborn, I'm not suggesting for one moment that the honourable member for Hammersmith has strayed out of order. However, it's the first time in my experience in the House in 14 years that I have been present at a speech that has lasted 3 hours in any form of committee or any form of proceedings in the House. I fully accept that the issues are serious that have been considered under this group of amendments, but so are a large number of the other issues of over 100 clauses in this bill. I'm obviously Minister responsible for the second half of this bill, and the government is anxious to make sure that this committee has the opportunity to properly scrutinise the whole of this bill. It must be plain as a pikestaff to everyone in this committee that the length of one speech at the beginning of a debate on the first group of amendments lasting this length of time is obviously going to carry implications for what happens in the rest of this committee if all of us actually want to get through the scrutiny of this bill in the order that you and I'm quite sure the rest of the committee would desire.
I'll go to that point of order, and it may or may not be of some concern to Mr. Blunt that at the end of the debate which is about to ensue, Mr. Slaughter has a second innings, if he so wishes. Mr. Alex Cunningham.
Thank you, Mr. Holborn. As you know, I, like others in this room, are relatively new to the House, and therefore I would seek some guidance from you as the chair of the committee. Is it in order for me or any other honourable member to raise campaigns and issues that are run by other members, campaigning for their CABs or campaigning for their law centres to be saved, particularly at a time when this bill will impact so tremendously on these particular organisations? Is it not right that we should point out the inconsistencies and perhaps persuade the members opposite that their campaigning and their attitude to the bills cannot actually be reconciled?
Well, the Honourable Gentleman can raise any matter he wishes, so long as he is speaking to the amendment before the committee. So if he wants to use one of those campaigns to illustrate a point pertinent to the amendment, then he or anyone else is perfectly entitled to do so. The Right Honourable Tom Brake.
Thank you, Mr. Holborn. I rise to speak.
Oh, no, sorry, I thought it was a point of order.
No, it wasn't.
Any more points of order? Right. Amendment 60 proposed as on the amendment paper. The question is that the amendment be made. Right Honourable Tom Brake.
Thank you, Mr. Holborn. I rise to speak very briefly, members will be pleased to hear. Just to make a few points about access to justice. And I think when the Honourable Member for Hammersmith opened his remarks, he did say that he was going to comment in some detail on what his party's alternatives would have been in relation to funding for legal aid. He didn't do that in 2.5 hours, 3 hours. Maybe he is intending doing that in his second innings, which I hope will be briefer. And, or there again, maybe my attention lapsed in his peroration, and he did, in fact, refer at length to what his party's alternatives were going to be. I'm very happy to give what
I'm very grateful to the honourable member for giving way. It seems to me a bit strange for his colleagues to be complaining about the length of speech when he now wants to add on the Labour Party's proposals. Can I ask him to consider the implications? Can I ask him to consider the implications if we are to do that, and to remind him that we're here as a Bill Committee to scrutinise the government, not the opposition plans?
I thank the honourable gentleman for his intervention. I'm quite confident that had the Labour Party deployed its alternative proposals, that would have been a very brief contribution to today's debate. The honourable gentleman referred to the early day motion, and indeed I do regret if funding is being cut from a range of bodies and a range of organisations, and I think that would be true of any member of this committee on either side. And the honourable gentleman's party doesn't have a monopoly of compassion, although I think he seeks to portray that fact. On the subject of mediation, I was very pleased to note that the Bar Council said that they were doing more work on training barristers to enable them to undertake mediation work. But I think also it is incumbent on the government to ensure that government departments, quangos, primary care trusts, any bodies that are in effect representing government also play an important part in being willing to undertake mediation. And I hope more work will be done on that to ensure that they are willing to and don't themselves rely on legal representation. I'm happy to do that.
I'm very grateful to the right honourable gentleman, and I note what he says about the willingness of government departments to engage in mediation, a point of view that I share. But would he not therefore extend the recognition of the approach to mediation to understanding that, of course, it only works when people are willing to enter into it, and that the idea that it will now be compulsorily the only option on the table means that in some cases it simply cannot succeed?
I thank the honourable lady for her intervention. She's right that mediation does require both parties to be willing to engage in it, but I think also often I think it's an attitude or an approach which actually facilitates mediation and makes that perhaps the preferred option. On the litigants in person issue, again, I think it's important that the government do extend the programme, which I know is underway, in terms of making all of these processes more open and transparent, so that if there are more litigants in person, then at least they have a clear understanding of the legal process they're going through, and that all the necessary advice is presented in an easy-to-digest form. On the decision-making process, again, this is something where the government can and should take action, and that is, it doesn't matter what decision-making process it is, whether it's referring to benefits, to immigration, anything that can be done to reduce the need for intervention later on, whether it's legal or otherwise, in other words, getting the decision right the first time, I think will help everybody, including government. And the final point that I'd like to make is in relation to research. I welcome the fact that the government are going to be undertaking research to look at the impact of these changes, and I hope that that will report comprehensively and promptly, so that if indeed adjustments to the policy are required, that the government will be in a position to take that action quickly.
Thank you very much indeed, Mr. Alban. I don't want to irritate committee members by taking too long. I can see that many honourable members are keen to get on to other parts of the bill. But I do want to speak to the amendments in my honourable friend's name, the member for Hammersmith. I think it's absolutely crucial that these amendments are discussed thoroughly, actually. It's a particularly important part of the bill. It goes to the purpose of legal aid. I think, Mr. Alban, I'm irritating the Minister already. He says something from a sedentary position which I'm afraid I didn't hear. But it's about the commitment to ensuring access to justice, which is, in my view, absolutely crucial. That should be at the beginning of the bill, in my submission to the committee. I think honourable members have made the point. I think that my honourable friend, the member for St Helens North, made the point that the government's plans are driven by the Treasury, chiefly, by the Chancellor of the Exchequer, rather than the Lord Chancellor. I think I have to agree with that. The reason I say that is because 23% cuts happen in his department. It's his department. I'm not sure what discussions he had with the Treasury or honourable friends in his party, but I do wonder why he accepted such a massive cut to his department. It means that £350 million come off legal aid, the lion's share of that from civil legal aid. What's particularly bad, in my view, is the fact that social welfare is to be affected the most severely. That is, in my view, the most vulnerable people in our society. I think it's been said on numerous occasions that there are no votes in legal aid, and I would tend to agree with that, because I forget how many times I've stood up for my former government when I've been in courtroom scenarios, speaking with colleagues, when I've defended our policy. The reality is we were not profligate with legal aid. There's been huge cuts to legal aid over many years. I think I'm right to say something of the order of 40% to criminal legal aid on its own. So the government, honourable members on the government benches, can't have it both ways. It can't be suggested, Mr Oliver, that we were profligate and then cut legal aid as well. Of course we did cut legal aid, in my view. But what we wouldn't have done is gone as far as the government are going. And there's a reason for that. It's no good challenging honourable members on this side of the House by saying, well, tell us what you'd have done then. The reality is this government have made a decision. The only priority in my submission of this government, I've seen it in every department, has been to cut the deficit. That's the main priority. There's no other consideration. I accept it's important, extremely important, and honourable members on both sides of the House, in all political parties, would accept and acknowledge that there's a need to reduce the deficit. But this government has a priority. But it's the problem, I think, the government have, it's their only priority, which is deficit reduction. So we come at this discussion from different points of view. We say we would have gone much slower. The cuts would have been there, they would have been bound to happen, but they would have gone over a much longer period. And honourable members on the government benches don't seem to acknowledge that point. Mr Oliver, you were not here for this morning's session, but I just want to pick up on a point made by the honourable member for Broxton in an intervention, and she makes a point about right to reply earlier in the debate, so I'm very happy to give way to her if she wishes. I think I'm right in saying that in an intervention she suggested that people run to litigation willy-nilly. Well, I stand corrected. I think that's what members of the committee thought she was saying in her intervention. I have to say I disagree entirely with that. In my view, that is not what happens in the present situation. I wonder how often she goes into a pigeonhole in her chambers, picks out a brief, unwraps the ribbon, goes to the back of the brief and picks out the legal aid certificate and thinks, well, hang on, there's the legal aid certificate, game on, let's have a trial. Doubt very much whether her or any honourable any member of her chambers has that attitude when it comes to litigation. In my view, members of the bar and the legal profession, solicitors, will advise their clients on the basis of the case. People don't run to litigation as a first option, in my view. There might be an argument, Mr Oliver, to say that, such as the National Health Service have a policy to say we're not prepared to settle. I think that's probably right. And I think other organisations as well might well have that policy. But I think it's unfair to suggest, if she's not suggested it, then I'll take it back, but I think it's unfair to suggest that there is a tendency to run to litigation as the first option. I don't think that is the truth at all.
The honourable member give way?
Yes, certainly.
I'm very grateful for the honourable member. He's as generous as ever. The point I'm trying to make is, first of all, as he knows, in criminal legal aid work, all criminal cases, very few exceptions, are in any event funded by legal aid, and it's not something you choose, obviously, to be prosecuted by the police. You find yourself in that position, and then you are taken to court. So it's very different from civil litigation, as I know he knows. My point is this. In the past, there has certainly not been a tendency to settle and to use mediation in the way that it could and should have been used. And that is the point that I am making. Law was always very expensive. And the good side of that was that it often meant that people looked at alternatives to using it. Then there was the proliferation of legal aid. My point is too many people then resorted to law when there might have been other ways to settle disputes.
I think I probably agree with the honourable member for what she says in relation to that. But I did think her earlier intervention suggested rather that people ran to litigation as a first option. As I've said, I don't want to reiterate the point too much, but I think...
On that point, I'm very grateful to my honourable friend for giving way. Wouldn't this argument have more force if the proposal was that you had to go through mediation first before you can access legal aid? In that case, you would resolve the issue about where it should go in its first priority, but you would not be denying people legal aid at the end of the process.
My honourable friend makes a very valid point, actually. But just to answer the intervention from the honourable member for Broxton, I think she'd agree with me. In my experience, lawyers tend to advise the clients based on the merits of the case which they're dealing with. I think I suspect I may have misunderstood the honourable member's point in her intervention this morning, but it did cause me some concern. Mr Osborne, I think there are some real dangers in the government proposals, and I'm concerned very much about them. I represent a constituency where it is pretty heavily socially deprived. It's increasing under the last 12 months. I think for every job vacancy, 27 people are chasing that vacancy. I think it's tripled in the last 12 months, which tells me it's no coincidence. I think that's something to do with the policy of this government. And I mention that because I do think that those are the people who need access to legal service. They need access to lawyers. Honourable members have made the point that CABs and other law centres and so on provide a good service without being lawyers. But I do think it's very important for people like me who represent a constituency where social deprivation is pretty high, that we have that in mind. I think there is a danger that lawyers will eventually close the door. Advice deserts, I suspect, will occur. I can name areas near to my own constituency where firms and solicitors are telling me that they cannot survive with the plans the government have. And if that is right, and they do decide to close the door because it's not viable economically, then people will be absolutely closed out of seeking legal redress. I'm sure that's not what the government intend, but I do think that is the consequence of what they plan. Certainly.
Thank you very much. The profile of my constituency is very similar to that of my honourable friend. And there's actually a family in my constituency at this moment, and they're pursuing a case of clinical negligence against a local hospital. They claim that their mother was neglected, having been admitted for a fractured hip, but then died of a septic ulcer. And under the bill, I just wonder what options would be open to them to take forward this particular type of case, because they fall into the same category as the poor people within my honourable friend's constituency.
It makes a very good point, Mr. Oliver, and I think that's the issue for me. And I'm not trying to make political points. It's not about political point scoring. I think I said at the outset, honourable members on both sides of the House accept that whoever won the last general election, there would be cuts, the deficit needed to be addressed, and no doubt we needed to reduce it. But, you know, we do have a different plan and a different approach to what the government seem to be running with. I'm concerned, as my honourable friend has pointed out, that people will genuinely be closed out of seeking legal redress with the plans the government have in this bill. I can't find, to answer my honourable friend's point, anywhere in the bill which would allow that constituent of his the legal redress that they require. No good saying to them, well, what about mediation? You know, how do you mediate in a situation like that? I can tell a story of my own family, Mr. Oliver. My brother, many, many years ago, was ill with stomach pain. He went to his GP, I think, 4 times in 3 days. He was suffering with severe stomach pains. And I think I'm right to say that his general practitioner prescribed him Gaviscon. He collapsed on, I think, day 4, was rushed into to Hull Royal Infirmary and died 2 days later. The general practitioner was negligent. There was no doubt about that. There was no mediation to be done with the health authority, with the National Health Service. There was no way of discussing it, getting around the table to try and resolve the issue. The fact was, the health service were not in a position, were not prepared to accept liability for that claim. Now, I tell that story, it's a very personal story to me, but I think it's important. If a constituent came with an issue like that, was not able to seek legal redress, what would they do? Where do they go to? Who would they see to get the support they need with litigation? It wouldn't be possible to get round the table, I suspect, and negotiate a settlement in relation to that. It needed litigation. That was the truth of it. It needed a legal fight, and it was settled eventually on the day of the court case, as they say, on the door of the court. But I think I've made 1 or 2 points. Some of them perhaps are not entirely relevant to the points that have been argued by my honourable friend this morning, but I do have real major concerns about the government's plans, and I do think people will genuinely be closed out of seeking legal redress with the proposals. Thank you very much indeed.
Thank you very much, Mr. Oliver. We are moving from, and I promise you, Mr. Holborn, I won't fall foul of this. We have been moving from discussion of the specific amendments and the new clauses to a more general debate about access to justice. And I just think it's worth pausing for a moment to look at what, in fact, that term means. Access to justice is a term that I think is difficult to define in any fixed way. My understanding of access to justice is a desire amongst people to, in fact, seek a form of justice that may not yet be available to them. And it actually brings with it a whole question mark about the validity of the system of law and justice within which we work. Now, those are huge issues, and they're not issues for this debate with respect to everybody concerned. We are working within a limited system. It is, I think we would have to all agree, a flawed system. It is a human system. It is a system that has evolved over the generations based upon not a universal provision, but limited access. And I think the term access to justice in the context of this debate, Mr. Holborn, is unhelpful. We should be looking at the phrase legal needs. It's a far more strictly defined criterion, and we're talking about a limited set of possible actions for securing existing legal rights within our limited system. That's what we're dealing with here. That's what the last government struggled to deal with, and the honourable gentleman, the member for Hull, spoke very well about the challenges faced by the last government, and indeed the challenges faced by all of us who work within a limited system. And that was the challenge, Mr Hollowbone, that faced the legislators back in 1949, because the choice for them was a start point. They either went down the road of creating a system of salaried lawyers who would give specific help and advice to the poor and the less well-off, or it would be a system of legal aid administered via private practitioners and the Law Society. And it was the second option. There were two options in the Rushcliffe report. It was that second option that formed the basis of the 1949 Act. That Act wasn't the start of legal aid and assistance in this country. Back in the 30s, there was an Act that gave access for what was then termed poor prisoners, a very archaic way of describing people in the criminal justice system. But there we have it. That was the language of the time. I will give it.
I'm very good. I actually tend to agree with the first part of his contribution, whereas it would be an ideal thing for the government to set out the principles of this bill. What's it intended to do? What's the scope of that bill? What's driving it to make its decisions on the scope of the bill, and what should be limited? And if he's suggesting that, I don't know if the government minister, when he's listening to this, will consider that and bring forward amendments at a later stage to actually address that issue.
Well, I'm very grateful to the honourable gentleman. I mean, the truth is there are two issues here, and I think none of us would be telling the truth if money wasn't part of this consideration. Of course it is, and it was a consideration for the last government as well. And, let's not hide from the fact. But it's more than just about raw calculations and treasury estimates. It is about the quality of the system that we can provide. And I think the challenge facing any government coming in 2010 was to accept the fact that there were limited resources, that resources would shrink, and how to square that shrinking level of resource with providing a system that would reach out to the poor, and not just the poor, but to those who are on the margins, who are vulnerable and who need real help. So I hope that's an answer to the honourable gentleman. I just want to come back to where we were at the time of the dawn of legal aid. It's been often described as one of the pillars of the welfare state, and it's been compared, I think, rather histrionically at times with respect to no speakers in this room, but certainly speakers elsewhere, to the National Health Service. In fact, the comparison is ill-judged. There was never a universal provision. It was limited in the 1949 Act to matrimonial cases in the High Court. And it was only through the decades that then followed, most notably as a result of the Widgery report in 1964, that we saw the rollout for legal aid for all imprisonable offences. So at that time, defendants going to the police station were facing a potentially imprisonable offence would get legal aid. And then in the 70s, we saw the rise of the Green Form scheme. I think a lot of practitioners in this room, former practitioners, would remember that. I think it was the 1974 Legal Aid Act that brought in green form advice which solicitors used, and which was an integral part of high street practice. I'll give way to
I'm entirely following his very brief but interesting history of legal aid, and I agree that it's changed over time. I think I made that point myself. I don't entirely agree with him that yes, it's not the same as the National Health Service, but it's often said there are three, sometimes four. I'm never quite sure whether it's a three-legged stool or a four-legged stool, the welfare state. Yes, we have NHS and education, which are largely free, although they have private components. But we also have the social security system, welfare benefit system. And I do think that legal aid fits into that. And I would not like to lose sight of the fact that access to justice, it's a constitutional principle, as well as the facility being there to help people who are in need, is as important. It may not be the same, but it's as important as those other three legs.
Well, I'm very grateful to the Joe, because that is another debate here. My concern with the amendments that he puts forward is that he's trying to enshrine principles in legal aid legislation that are never part of the system. And what he's in effect doing with respect to him is potentially opening the door to a whole raft of litigation, of judicial review, about the true ambit of legal aid. You may recall in an intervention I made to him very early on in his speech, some hours ago, about my concern about the true potential unforeseen consequence of his amendments. I'm sure that he would agree with me that he's not seriously suggesting or his party are not seriously suggesting that there can be a wholesale expansion of legal aid in these troubled financial times. And I'm grateful for that nodded assent to my assertion. So therefore, he's got to ask himself, and the party opposite need to ask themselves with respect, greatest respect to all men, the question, what do these amendments actually achieve? Do they actually open the door to that potential expansion, which I think is impossible in these limited times, or do they in fact go anyway to advance what they would regard as the important case for the retention of legal aid services? My problem, and I will give way to the Honourable Gentleman.
I think you ask what is my honourable friend Hammersmith trying to achieve with the amendments. I think he's actually trying to ensure that the government and the public purse save money into the future. For example, according to the Citizens Advice Bureau and their business case for legal aid, they say that for every £1 of legal aid expenditure on housing advice, the state potentially saves £2.34. On debt advice, it's £2.98. On benefits advice, it's £8.80. And on employment advice, it's £7.13. Surely the amendments being put forward make sure that we continue to make those savings rather than ramp up expenditure outside the legal aid system.
Well, I'm very grateful to the Honourable Gentleman, and I'll address his points directly. He makes a very good point about the dangers of just focusing upon the legal system and forgetting about the fact that there are other areas of public life which are failing our citizens, and I think particularly of welfare benefits, where 92% of decisions made by the DWP were overturned in tribunal. A complete waste of everybody's time and resources. And therefore I take the point that he makes very seriously indeed. I'm not sure that these... I'll just address the Honourable Gentleman first, if I may, and I'll come to my Honourable friend in a moment. I'm not at all convinced that these amendments actually do what he wants to. I think there may well be times when we come to further debate about other parts of the bill that we can deal with these issues head on. But can I just take a moment before I take further intervention to address the proper point that he raised earlier about law centres? I just want to deal with that as concisely as possible. I mentioned at the beginning of my remarks, Mr. Hollowbone, this decision that was made not to go down the line of employing lawyers to advise people who are poor or vulnerable. Well, that was the decision in 1949. In 1970, we saw the birth of the first law centre, which represented a different approach. It represented the direct employment of lawyers in giving specialist advice, legal advice, to people who were in a poor or disadvantaged position. A great initiative which has given birth to 56 law centres, one of which is in my constituency, which the Honourable Member for Stockton North referred to. And he also referred to the support that I've been giving to my law centre and the argument that I put forward both in this House and in my constituency about the need for a reform to the way in which the law centre is funded. And I mentioned the phrase block funding, and I stand by that, because I do strongly believe that it would ease the role of law centres to stop having to worry about whether somebody coming into them was a debt problem or a housing problem or a benefits problem, and deal with them as a legal problem within block funding. Now, I think all the law centres, mine included, will accept that probably the funding would be less than what they're getting at the moment. I go back to the issue about finance. But what I wanted to make clear, Mr. Hollowbone, was that the views that I've expressed locally are views that I am proud to express today, and they are views that I will continue to express in the context of this argument. I've come to the view, Mr. Hollowbone, that arguments about scope and whether things should be in or out are actually missing the point. Because what we're dealing with here are ordinary people coming in off the street, not saying to the law centre, look, I'm a debt problem, but coming in with human experience, human concerns, and who need legal advice. And therefore I will continue to make that case, and I make no apology whatsoever for doing so. And I'd like to say to the Honourable Gentleman, if he thinks there is a contradiction, well, I disagree. I am doing my very best for my local law centre, both in committee and both in my constituency, to make the case, and I will continue to do so. I'll take an intervention from the Honourable Gentleman.
The Honourable, as always, is making a persuasive case, but to me he's putting forward an alternative method of funding access to justice, to use a phrase he doesn't like. It may be an extension of the principles that I spoke about in the Access to Justice Act, in the sense that it is looking at society in the round, whether it's locally or nationally, and saying how do we provide what he calls legal need. It may be he's looking for, he wants to copy a system like the Australian system or something that operates elsewhere. I'd be very interested to go down that route. But this bill is not that. And we have to address what's in this bill. And this bill is, at the moment, disenfranchising people. It's not providing an alternative.
Well, to the Honourable Gentleman, he's absolutely right. The evidence of Julie Bishop, I thought, was extremely compelling. It was the one part of the evidence we heard in the sessions that offered a constructive alternative. And I was very impressed by her evidence about the fact that, in fact, over 200 law centres in Australia are funded by the block funding system that I very much support. And I think that is a model that could very much work in this country. We've seen already the beginnings of a move to that by the announcement of the second of funding for 20 million pounds of funding this year. Now, I don't think it's a job for the Ministry of Justice alone. I think it's actually a job for Cabinet Office and other departments of government to come together and realise that where we have a potential legal aid desert situation, and Swindon would be a case in point where without the law centre we wouldn't have proper local housing law advice, that with an avoidance of duplication of service we could actually make our public money go much further. I take an intervention.
I'm very grateful to the Honourable Member for getting away once again. I think he's making a case for this bill to actually fall and for the government to reconsider their proposals and to come back with a more coherent strategy which will do all the things that you're wanting to do, what the Honourable Members wanting to do, and what we want to do, and also will maintain some justice for poorer peoples and moderate income. So if that's what he's advocating, I think our side would agree very much with what he's saying.
The Honourable Gentleman is quite right to ask that specific question. What I'm saying is that I think this bill in isolation is enough. I think that Acts of Parliament, we all kid ourselves at this place by thinking that Acts of Parliament can be passed and can make the sort of changes that we claim, whether we're on the opposition side or the government side. I think, therefore, I would caution the opposition in making some of the more gloomy predictions that it does about the future of publicly funded legal services. Because whilst I could be accused of being an eternal optimist, Mr. Holloway, I do believe that we still live in a country, even after these reforms, where we're spending the best part of £1 billion on civil legal aid and £1 billion on criminal legal aid. And we shouldn't lose sight of that fact. Now, I'm conscious of time, and there are many other things I'd like to say. But the truth is this, that when we reached the 1980s, after the Green Reform Scheme, we reached a position where about 80% of the population of England and Wales was eligible for legal aid. Now, both parties realised that that was not sustainable. And we saw a decline in that proportion to the position that we've reached now. And it was aided, most notably, by the Access to Justice Act 1999. Some people thought, with respect to the party opposite, that the use of that particular phrase to describe that bill was a contradiction in terms, because it did, at a stroke, remove significant areas of civil work from legal aid altogether. It was a very workmanlike bill. When you read the provisions of the Act, none of the grandiloquent phrases that we see in the amendments laid by the Honourable Members opposite appear. There are no attempts to try and restate the European Convention of Human Rights, no attempts to try and give judges the opportunity to widen the ambit of legal aid. It's a very carefully drafted piece of legislation which was designed to restrict access to legal aid. That is the fact of the matter when it comes to the 1999 Act, and therefore it is in many ways no different to the legislation that we see before us. I won't deal with each proposed amendment in turn, Mr. Holloway, because time sadly does not permit me. But what I do say is that attempts to try and restate general legal principles in the context of legal aid are very dangerous, for the reasons that I outlined at the beginning of my address. But we need to be looking at limited needs. This is a limited system, and it is a system within which we as human beings have to operate. I well accept the points and the concerns made by members opposite. They are made sincerely, but they forget the context of the times in which we live and the very nature of the limited system within which we work. So, on that basis, well, I will give way finally to the Honourable Lady, my honourable friend.
I'm grateful. I wondered if the Honourable Gentleman shared with me just perhaps some level of confusion about the points that are being made opposite. And I do say this respect, I also take the point the Honourable Member has just made about all the discussions today being made in sincerity with a lot of experience on both sides of the committee. But when we hear the member for Stockton North give his point that in fact the opposition here are trying to save money, the points they're making. But my note from earlier regarding new clause 1, little f, made by the Honourable Member, the Shadow Minister, was really to make the point that they didn't wish to put a financial burden, and that was less of a consideration. The truth of the matter is, we are dealing with public money. The Minister does have a responsibility, and ultimately we will always have to balance that with the access justice to points which the Honourable Gentleman makes.
I'm very grateful to the Honourable Lady, and in the final analysis, Mr Holloway, I'm afraid the amendments have too many ambiguities within them to withstand close scrutiny. When in Amendment 60, right at the beginning of the amendment paper that we have, Clause 1A, little a, providing legal services to those unable to afford it, is not properly defined. That is immediately open, I think, to a whole range of different interpretations, which could lead to the sort of problems that my honourable friend, the member for Erewash, has raised. If the opposition are serious about wanting to ration and properly direct scarce public funds, these amendments go no way at all to achieve that. In fact, they endanger that very laudable aim. Thank you.
Thank you very much indeed, Mr Holloway. It is a great pleasure to speak after the Honourable Member for Swindon South. He brings a great deal of expertise and I think credibility to the work of the committee, and he particularly, Mr Holloway, opens up the opportunity for me to speak to the two amendments tabled in my name, which very much follow on this point. And I hope you will agree that these amendments are actually quite specific. They're not theoretical or philosophical amendments. They're rather pragmatic amendments, and they very much go, Mr Holloway, to looking at these issues of cost effectiveness, value for money, and ensuring that we spend legal aid money in the best possible way. Now, I am in tabling the amendment number 83, I'm seeking for the analysis around the debate that we've begun to have this afternoon around the relative costs of legal aid and the savings both within the legal system and beyond it properly to be analysed and understood before we are in a position of making the kind of radical changes to legal aid coverage which this bill proposes. And I do that very much in the current financial context, when it is particularly important that we understand the widest possible and the long-term impacts on public spending and the cost to the public purse. And I think the government itself has really accepted that that is the right way in which to approach consideration of public spending. I think that it has accepted the philosophical justification for prevention where it's possible, spending money up front on preventing problems down the line is both in many ways preferable for the quality of experience of individuals and in terms of long-term cost, a more cost-effective approach too. But that prevention up front approach is really missing from the whole structure of this bill, which simply goes to cutting funds at the point of crisis, rather than looking how upstream we could be spending both legal aid money and other money more effectively to avoid that point of crisis being reached. I want, in speaking to Amendment 83, Mr Holloway, really to look at costs in two groups. In terms of the way in which I would like the government to bring forward their analysis and assessment. The first group of costs are the group of costs that which this bill could give rise to within the legal system itself. And I think that there are at least potentially a number of costs which will flow, which will potentially increase from removing social welfare legal aid from scope. And I look first at administrative costs to the legal system and the complexity, which I think the Honourable Member for Swindon South was beginning to talk about in terms of determining just what is in scope and what is not. I have very considerable sympathy with what he says about looking for funding approaches that can begin to deal with those boundary issues, because I think he is absolutely right that the most intractable problems are usually the problems that do not come in isolation. They come in clusters. They come as a result of one event which catapults a whole train of events. Events within categories of family, debt, employment, housing and social welfare benefits can all follow on from, for example, a relationship breakdown. And looking for funding mechanisms which are flexible enough to respond to that clustered nature of legal and justiciable and social problems, I think the Honourable Member is absolutely right. And it is a pity that this bill really has not made an attempt to begin to open up thinking about how that could be designed. Instead, what I fear we will have, Mr Holloway, is added cost to the system from trying to see where those boundaries actually sit and which bit of a particular person's circumstances are within scope for legal aid and which bits are outside of scope. And indeed, the Legal Services Commission itself suggested, I think, in its Green Paper response, I hope I'm not misinterpreting the thrust of what it was saying, that finding that boundary, making the proper analysis of where that boundary sits, could end up costing more than the actual saving to legal aid. And so I think it is absolutely right that we have a really careful analysis from the government of what they think the impact of the costs to the legal system of administration will be by leaving some matters within scope but taking whole categories of law out. I'm interested in some of the provisions in the bill which, whilst they may have some merits, and I look forward to our debating them in this committee, will themselves require further analysis and decision-making within the legal system, which will inevitably produce some administrative cost. So I'm sure, for example, that we can expect challenges and litigation around whether an individual should be given exceptional funding, provisions of, I think I'm right in saying, Clause 9 of the bill. I think it's important that we look at the impact of some of the provisions of the bill on the costs that will now be borne by local authorities. They will be required, I think, to pick up some legal costs which are currently met by the legal aid budget, and they will have to pick those costs up at the private rate in some instances, which will of course be higher than the legal aid rate which might currently pertain. I'd very much welcome in his response the Minister clarifying whether my interpretation of that risk is correct, and if it is, whether he has had any discussions with the Local Government Association about the implications for local government of that possibility, and whether any analysis of the potential knock-on costs for local government has been made. I think we can also expect that in other categories of law, where individuals are no longer able to use particular categories of law because they're now outside scope, they will look to move into other categories of law which are inside scope. The absolute classic area, I think, is the boundary between immigration and asylum, where I think that we can expect that some cases which are currently covered by legal aid as immigration cases will not be in future and will transfer into becoming asylum cases, and that we will actually find ourselves in a position where we are engaging in more costly legal action and possibly wrong category legal action, which will again increase costs to the system. And for example, where a parent is unable to get legal aid to challenge removal or deportation on the grounds that they have British citizen children, a human rights judicial review may be sought in the name of the child, and that too would be a much more complicated and costly procedure. So I think we would very much like to understand what analysis has been made of the risks of displacing current costs in some categories of law into new costs in other categories of law, and particularly potentially inappropriate categories of law. There will be additional costs, I think, too, to courts and tribunals as a result of dealing with more litigants in person, and I come on to that in a moment when I make my remarks in relation to my amendment number 89. And finally, I think we will lose the ability for the system to learn that arises from being able to deal early with categories of law within the legal aid system and make clear judgments which then apply and can be applied in future like cases. And in particular, I refer to the possibility that some important currently legally aided test case work will no longer fall within scope. And I speak with very strong personal experience of this, Mr Hollowbone, having been in my previous role at Child Poverty Action Group, able to use legal aid funding to take a number of test cases through the system, which I think have been extremely helpful in terms of removing future such cases from the system, because we then arrive at a position where we've got absolute clarity of law. I'm very happy to take an intervention from our
I think she's demonstrating a whole batch of areas where there could be unforeseen consequences of the proposals. But does she share my concern that the general public as well will want to see a system that's fair? And I think that they will have, does she agree with me, that they will have great difficulty, and I just wonder what papers like the Daily Mail will make of this, where someone can actually get legal aid from an asylum case, but they can't get it to pursue a case in the health service for a child that's been brain damaged. Now, I think that that will make it very, my own view is that the public perception of that will be that that is wrong. It can't be right for those people who are faced with a problem, the child has been injured in a hospital with brain damage, not being able to pursue a case because their legal aid has been removed.
Well, clearly, there is obviously very deep disquiet about what the implications of the provisions of this bill could be for some of the most serious clinical negligence cases, and I know that we will be having further discussion of that point as we go through this bill. But my honourable friend is right. Public perception of the validity, if we like, of the system is extremely important. And I don't think that we do the system any favours if what we actually begin to do is open up the possibility that people will seek to manipulate their access to legally aided categories of law, which I think he is absolutely right to highlight. So those, Mr Hollowbone, are my concerns about where there is at least the possibility of increased costs within the legal system. I do not say that all those increased costs will arise. I simply ask in my amendment that the government publishes an analysis of the likelihood and potential impact of those costs before it proceeds to remove whole categories of law from the ambit of legal aid. But I also want, in the context of Amendment number 83, to expand on the point that I think was first raised by my honourable friend, the member for Stockton North. It's very confusing. You've got North and South spread across the committee. He raised the wider cost to society where legal aid is not available and where social problems are therefore displaced to other parts of the public purse. Now, when working well, I think what we would be looking for with social welfare legal funding would be to create a virtuous circle where, as I think the Honourable Member for Swindon South was suggesting, or it may have been the Honourable Gentleman, it may have been one of his colleagues, that part of the problem actually wasn't to resolve it by legally aiding people to challenge bad decisions, but to get good decisions in the first place. And that is just absolutely right. And I think the example that was given of the exceptionally high success rate of appeals in relation to welfare benefits absolutely makes the point. And I think that the ideal is, of course, to improve decision-making within the social welfare benefits and other systems, and not to have to keep on relying on a ratcheting up of legal cost. But I would say two things specifically in relation to that high figure that do cause me concern about the possibility that costs will continue to increase. The first is the polluter pays concept is now, of course, completely lost. But has been, I think, one that's been of interest to honourable members across the House for some time. That one way of actually encouraging departments like the Department for Work and Pensions to improve their decision-making is to make it costly for them to have to keep dealing with legal challenges and challenges in tribunal. And I'm interested in why that concept is no longer of attraction to ministers. It's certainly one that I think merits some exploration and analysis. And again, that's the analysis that I ask ministers to bring forward in the course of the passage of this bill. The second thing I would say is that we naturally are particularly mindful that additional costs or additional challenges in terms of both decision making and the public interpretation and understanding of such decisions is going to be increased at times of significant policy change, such as we are about to see in welfare benefits, such as we are currently seeing in relation to housing benefit and to housing policy. And I think there is a very real question to ask about whether during periods of transition, when I think we can expect considerably higher levels of challenge to a new system as people test its application and its boundaries, whether it would not make more sense to smooth the passage of policy changes in other government departments by ensuring, at least during the transition period, that the possibility of funding to make quick, focused legal challenges is not removed. And I know that is a view that honourable members opposite have expressed to me in the past, and I'd be very interested to hear the Minister's comments in relation to that. As my honourable friend, yes, I'm delighted to give way.
Manfred is absolutely right, and she's going through the different categories where costs can be incurred or caused even by parts of the public sector. We also have a specific problem at the moment that reassessment of those claiming disability benefits is throwing up very, very high numbers of appeals. Now, one of two things can happen. Either people are going to appeal, and a very high percentage of those appeals are successful, or they're not, and they're going to lose welfare benefits unjustly in many cases. I every week come across cases like this in my own constituency. People do not have the means, ability to appeal decisions themselves. They need some form of advice and assistance. I fear, although I agree with her about the additional costs, the one way the government is saving money is by effectively making people disappear and the benefits register. Now that may save money, but I think it will be a pretty disgraceful way of doing so.
I agree.
Well, I'm with my honourable friend, the member for Stockton North, and trying to think the best of all honourable and right honourable members in this House. And so I hope that, do not think that it is a deliberate government intention to shut people out of welfare benefits to which they ought to be entitled. But it is certainly the case that we are seeing an exceptionally high number of successful appeals currently in the Social Security Tribunal in relation to the decisions that have been made about eligibility for the employment and support allowance and the work capability assessment that claimants have to go through. And I'm sure there is not an honourable member in this committee who has not had a constituent come to them with a tale of woe about the work capability assessment and the difficulties of applying for a benefit to which it is quite clear that they are entitled. I think it's of note too, Mr Hollowone, that Professor Malcolm Harrington, who was commissioned by the present government to provide expert advice on the workings of the work capability assessment and the employment support allowance, has specifically highlighted again how good decision making in tribunal can be very useful to DWP in ensuring that they don't repeat mistakes, process mistakes and decision mistakes. And that I think this is very much a transition point that Professor Harrington is actually making. As you bring in a new system, you specifically want, as quickly and as efficiently as possible, to get absolute clarity on the boundaries of that new system. And access to the tribunal is a way of actually enabling that to take place.
That is true.
I'm delighted to
well, in the yin and yang spirit of this debate, for every positive point my honourable friend makes, I have to make a negative point. The converse of what she's saying is, if there is no right or ability to appeal, then that depresses the level of decision making. Now, that may not be an automatic response. I don't say that there are people sitting in the Department of Work and Pensions saying, yippee, we'll be able to make a high level of poor decisions now. But the net effect is that, and I think that is only common sense. And that's what I fear. Because once people have their benefits stopped, and this happens just like that, their benefits are stopped, and then suddenly they are without means. And they're without means. I have food banks operating in my constituency now. I have charitable institutions, churches and so forth, giving people money because they have no other means of support. In the end, now that may be a short-term gain as far as money going out of the benefit system is concerned. In the long term, that is going to mean a greater cost to the public purse.
Well, my honourable friend is right. Of course, it's a shocking outcome for the individual, a particularly shocking outcome when it's a benefit to which they are entitled and should have been in receipt. but it's a bad result for the local economy too. If people are not receiving the financial support to which they're entitled, that does have a knock-on effect on wider local economic prosperity. And whilst I appreciate that this may stray quite far from the cost-benefit analysis of legal aid at first blush, in fact it's an important consideration which seems to have been swept aside. Now, I do appreciate how very difficult it is to quantify the relationship between legal aid spending or lack thereof and social consequences in relation to debt, in relation to health and well-being, in relation to economic performance in the local community, and so on. What I am disappointed about, though, Mr Hollowburn, is that no attempt has been made by the government, as far as I can see, to try to do it. And it is not that there is no science there, at least to make an attempt. Citizens' Advice, in their business case for towards a business case for legal aid, did try to do that. Now, this is an analysis that I know has not been without criticism, but it at least has begun to ask some important questions that I think it is right that the government should come forward and seek to answer. And I think, in all fairness to Citizens' Advice, they have made strenuous attempts to build as robust a case as they possibly can. They've worked with the Legal Services Commission and with the Legal Services Research Centre to undertake this analysis, and whilst it of necessity produces something of a theoretical answer, I think it's a good first stab that I would be very interested to hear the Minister comment on, because of even a fraction of the analysis that Citizens' Advice have made of the knock-on costs in the system elsewhere in the social system of reduced legal aid spending are correct, then we are substantially increasing expenditure to the Exchequer elsewhere, for example, in relation to the social spending that's incurred at local level, as well as by central government departments too. And a whole host of issues are apparently, if not causally linked, certainly correlated between housing, homelessness, debt, employment and discrimination problems, children's educational performance, if, for example, the family are unable to meet bills and parents are stressed, the family relationships and personal relationships come under strain, and the knock-on costs there to child well-being, to supporting children increasingly in single-parent households and so on. And I just ask ministers why there has been no apparent consideration of these wider social costs, or if there has, in what way it has actually informed the design of legal aid in this bill and the proposal to remove whole categories of social welfare law from scope. I'll give way to my honourable friend.
I'm very grateful to my honourable friend for giving way once again. Isn't this exactly the point that was made from the opposite benches here, that this bill is money-led? It's about making your share of the cuts to meet the budget deficit plans. And what's happened is that the consequence of that is that other departments which might have financial implications, for, have not been involved in this process. So what you've got is a policy that doesn't really see what the implications are of the bill, if enacted in the way it has, on other departments and other budgets.
Well, obviously I'm not privy to what discussions have gone on in government and between government departments and different ministerial teams in relation to this bill, but it certainly looks very like that to someone looking at the situation from the outside. So, Mr Hollowburn, I do feel very strongly that some more detailed report and analysis of the government's consideration of the cost consequences of their legal aid proposals is something that should be brought forward to this committee, to the House, before this bill completes its parliamentary passage. And I would say, in a spirit of encouraging ministers, that of course not all the consequences may be bad, but we need to see that properly analysed and explored. I mentioned, Mr Hollowburn, that one area where I thought we would see the risk of increased costs as a result of this set of proposals was that we are likely to have a rise in the number of litigants in person in our tribunals and in our courts. And my second amendment, number 89, very specifically addresses this point and asks for a particular analysis to be presented by ministers of the likelihood of an increasing presence of litigants in person and again the costs that would result from that. There's been very considerable concern, I think, from people who have supplied written and indeed oral evidence to this committee and to the government's own legal aid consultation, and to the Justice Select Committee too, about this risk of greater numbers of litigants in person and the very considerable difficulties that would cause both for the court system and for the individuals themselves. We already know that litigants in person tend to be younger, more poorly educated, with a history of problems such as violence, depression, substance misuse, mental illness. They come with clusters of problems more frequently, and if we are to bring more such litigants into our courts, I think we can already see that that's a very fine-need group of litigants who will come with additional associated costs. The government's literature review itself concerning litigants in person states that most research suggested that litigants in person may experience a number of problems which in turn impact on the court. For instance, the research pointed to problems with understanding evidential requirements, difficulties with forms, identifying facts relevant to the case. A number of sources also pointed out that litigants in person may have difficulty understanding the nature of the proceedings, were often overwhelmed by procedural and oral demands of the courtroom, and had difficulty explaining the details of their case. Many unrepresented tribunal appellants and applicants felt ill-equipped to present their case effectively at their hearing. They felt intimidated, confused at the language, often surprised by the formality of proceedings. Whilst I'm sure that the most vulnerable litigants in person would certainly be likely to experience all of those consequences, I think it's also the case that, in fact, that by definition of the nature of court proceedings, and particularly our adversarially based legal proceedings, is that many of us, forced to go and litigate for ourselves with a direct emotional stake and potentially financial stake in the outcome of a case, would find that those were exactly the emotions that were excited in us too. Problems may also be relevant for those engaging in mediation without legal representation, and we've had considerable discussion this morning about the efficacy of mediation. Here again, I think it's important to recognise, as was said earlier, that mediation is on a continuum, and that it's important that we ensure that the access to legal advice is there at the right point in the process. One study which was conducted by Peterson in 2010, found that parties in mixed representation cases, where one party was represented and the other was not, were more likely than cases where both or neither party were represented to report feeling unprepared to mediate. And so I think we've got a real picture of the difficulties and risks of an increased amount of litigation in person because these individuals feel that they cannot go through mediation first. I think we also need to recognise the difficulties for the court in dealing with more litigants in person in terms of case management, and particularly the difficulties where there may be lay members of a tribunal who will especially, I think, rely on the guidance of the lawyers in court representing both appellant and respondent, and the steer which that expert legal that advice can give to the tribunal too. And particularly, I think it's also important that we recognise in the more complex cases that what is going to happen, especially at first tribunal, is that there's going to have to be a great deal of sorting out for litigants in person that can currently be dealt with and cut through by legal representatives, and which will not be available if those litigants can no longer access legal aid. So, for example, the legal advisor will be able to look at the real substance of the case, possibly divert the case away from legal action altogether if it lacks sufficient merit, avoid the possibility that the claimant will present irrelevant or unsubstantiated facts, can very clearly distinguish between the points of fact and points of law and which of them is appropriate to bring forward to a tribunal. And, of course, without that cutting through by a legal professional, much more time is going to be spent actually in the courtroom trying to negotiate and explain all of that to the litigant in person, potentially sending her or him away to bring back different evidence or to come back with different arguments, and so repeated attendance by litigants in person could be another consequence, which will add further costs and increased court time. I think it's also particularly an issue in the upper tribunal, where it's much, much more likely that what will be appealed will be points of law, and where it would be exceptionally difficult, I would argue, for most litigants in person to make an efficient and effective case. So I think that the risk of repeat applications, and therefore potentially judicial review proceedings on the part of those who, deprived of any legal advice and assistance, have understandable reason to be dissatisfied with the result of earlier proceedings may increase. And indeed, such applications and judicial reviews may in many cases not only be understandable, but actually necessary if the individual's understanding of what was or was not relevant, or ability to collect and present evidence in an earlier appeal, has meant that the decision on that appeal does not address the substance of her or his case. So all of these risks would bring additional costs to the public purse, and very specifically to the legal system. And I very much hope that ministers will want to respond to explain just exactly what analysis of these risks they have carried out. I therefore, in addition to supporting the amendments that have been proposed by my honourable friends today, which are the broader philosophical questions about the purpose of legal aid and the way in which it is or is not adequately reflected in this bill, I very much hope that the pragmatics of the workability of what the government is proposing will be properly aired before this committee too.